Mistake number 9. Contacting the witnesses. Not every defendant who reaches out to the state's witnesses is trying to tamper with evidence or intimidate a witness. Sometimes, a defendant is just trying to take a hands-on approach and figure out what the case is going to look like. The problem with this is that, regardless of your actual intent, you have placed yourself in a situation where the witness can get you in trouble by telling on you, and you can't disprove it. If the prosecutor or judge hears that you contacted a witness, they aren't going to listen to a bunch of back and forth about, well, I was just asking them why they were telling these lies. You're going to be wrong right off the bat for reaching out to them at all. Defendants seem to know this in a situation where there is no relation between the defendant and the witness. But sometimes defendants don't think about this in cases where the defendant and the witnesses are family, friends, or knew each other before the case in some way. Direct contact between the defendant and the witness is not required. If you reached out to someone else to reach out to the witness, that will still count. I once had a defendant get in trouble for just poking a witness on Facebook. Steer clear from them, and if you see them around town, turn around and start walking away immediately to protect yourself from future allegations. If you drunk dial them in a moment of late night weakness, those phone records will seal your fate if they turn you in. Reaching out to witnesses is not only a great way to receive new criminal charges, but it is also a violation of your current bond conditions. That means that your bond will probably be revoked and you will sit in jail until your case finally goes to trial. When you live with the witness. People often ask me in a case like a domestic assault, how am I supposed to stay away from the witness? The victim is my spouse and we live together and plan to stay together. No one is probably going to come to your house and check to see who is staying there. But if there is some new disagreement that happens at that house, you'll be the one the police come after. You could just be taking a shower on the other side of the house and not even know that your spouse got mad at you and called the police. There wouldn't even have to be a new charge. You're in trouble for being there at all. Now your bond can be revoked and you're going back to jail. Do domestic assault defendants often continue to live at home in violation of their bond conditions? Yes. A lot of defendants can't afford to stay in a hotel for 6 months while their case is pending. But be careful if you have that kind of partner that keeps the police on speed dial. Some defendants actually go back to court to get their bond conditions amended so that they can be in the house together, which is the best way to handle it. Why defendants reach out to witnesses. I once watched a case where a defendant was accused of reaching out to the witness in the case. The prosecutor asked the defendant, "Did you try to call the witness in your case?" And the defendant said, "Yes, I did." The prosecutor asked, "Didn't you know that you weren't supposed to contact the witness directly?" And the defendant said, "Yes, I knew that." Finally, the prosecutor asked, "Well then, why didn't you go through your lawyer to reach out to the witness?" And the defendant said, "Because I couldn't get my lawyer to do it." Defendants often try to take the case into their own hands when they feel like no one else is working the case. An attorney who identifies himself or herself as the defendant's attorney is able to contact the witnesses directly to ask them questions about the case, although the person is not required to speak with the attorney. You can either give the witness information to your attorney or leave the person alone, but do not try to contact them yourself.